Welcome to Law Sessions. I am Jennifer Housen. We're entering the area of criminal law, and this is the very beginning of a series that we will be going through. We start off with what is a crime? How do you define it? Well, a crime is an act or an omission which is punishable by law upon conviction. That said, however, you would need, of course, to not have a valid defense for having committed that act or that omission. When we speak of omission, usually the omission is something, or a duty rather, that the law has imposed on a particular person, and the fact that it is illegal is either made so by legislation or the common law. In considering someone's act or omission a crime, the question, of course, is what are the objectives of the criminal law? And there are several. We can put them into 5 broad headings, basically. And the first, of course, is retribution, which is that offenders should, in fact, face punishment for their actions or omissions. Then the second is, of course, to deter them. So there's deterrence, to discourage specific offenders, so individual deterrence, and also deter the public at large, which is sort of a general deterrence. Then, of course, you're going to protect society by restricting offenders' freedom, and this would be incapacitation. There is, of course, seeking to transform an offender into more a productive member of society, in which case the idea is one objective being rehabilitation, and the last objective, of course, restoration, being that the offender should repair the harm that they've done to the victim. Now, when you look at these objectives, they really need to be contrasted with the American Model Penal Code objectives. And the American Model Penal Code is really a framework whereby it's a non-binding set of guidelines that the American Law Institute prepared so that America as a federal government framework, legislators, of course, can look to this when they're drafting. So when you look at the American Model Penal Code objectives, there are 5. They're slightly different, but somewhat similar. And the first is to prevent unjustifiable harm to individuals or the public interest, to control persons who are prone to criminal acts, to protect faultless conduct from being criminalized, to clearly define what is prohibited conduct, and to differentiate between serious and minor offenses. Now, as we get into the meat of the matter, we need to look at the elements of a crime and what constitutes the makeup of a crime. The first is the actus reus, which is the guilty act or the omission. There's then the mens rea, which is the mental element, meaning the guilty mind or the intent of the offender. Then, of course, the actus reus must coincide with the mens rea, and this is the concurrence. There's then also causation. It must be the act of the offender which causes the victim harm. And lastly, it must be that the offender has no valid defense, because if he has a defense, it doesn't matter if there's an actus reus, that he had a mindset to do it, that the actus reus and the mens rea coincided, and that the act actually caused the victim's harm. It must be that there is no valid defense. That being said, then you have a fully completed crime. In order to really appreciate how actus reus, mens rea, concurrence, causation, and the lack of a valid defense all come together for a completed crime, it is necessary over the next few lectures for us to really consider the anatomy of specific offenses. And in order to do that, we will look at them under grouped headings, and these, of course, will include offenses against the person, for example, assault, battery, murder, homicide, really. We will also look at offenses against property, so theft, burglary, and arson. We will also consider sexual offenses and what are the actus reus, mens rea for, say, rape and sexual assault. And we will also look at participatory offenses, which include inchoate offenses and accomplice liability. We'll also consider offenses involving animals and that group of offenses there. In particular, we will look at, for example, the Animals Act, and we will also maybe consider cruelty to animals. We will also look at a group of offenses against the public, which will include things like riots, obstructing the highway, and also terrorism. And lastly, we will look at offences against the state, where we will consider treason and, to a minor extent, espionage. That right there will be the total sum of the various groups of offences that we will consider for criminal law. Once we've established that an offence has been committed, the next question is what happens to the offender? He goes before the court, but which court? Well, your options are either the magistrate's court or the Crown Court, and it is quite different in each. The first thing is that you tend to find that in the magistrate's court, there is no jury. It's usually a judge sitting alone. Now, you have offences which are either summary offences or offences which can be tried either way, meaning that the offence can be tried in the magistrate's court or in the Crown Court, and we will go into that in some more depth in our next lecture. But you tend to find that this is a less expensive way to go because you look at whether or not a full trial would be required. You look at the public's interest among other things. So generally, when there is no issue or conflict with what the defendant believes the facts are, but really the defendant is not too keen on what the result should be, meaning it may be that yes, he's admitted that he's stolen something, but whether or not he should get a suspended sentence or whether he should go away for a period of time, then that may be where you've got the conflict and then it is dealt with there. Then it does take less time because the evidence that is brought is usually in some sort of written statement or written sworn statement, and then it is a judge who reviews that. So by and large, it tends to be less serious crimes. In contrast, when you look at the Crown Court, this tends to be before a judge and a jury, and it takes offences or it listens and makes decisions on offences that can be tried on indictment or which are triable either way. Now, when something is triable either way, it's when it's triable either as a summary offence or as an indictable offence. Now, going to the Crown Court is obviously more expensive. You're going to find that you're going to need a barrister or an experienced solicitor who is an advocate. And of course, then it makes it more expensive. It takes more time. And so usually you're looking at only the more serious crimes which tend to go this way. Now, as I said, with either way offences, they can be indictable offences or summary offences, and it can either be heard in the magistrate's court or in the Crown Court. Now, if the magistrates have made the decision that they are able to sentence within their sentencing powers and they are able to deal with the matter before them, then the defendant may even elect to have it dealt with on a summary basis before the magistrates, or he could choose on indictment to be tried by his peers in the Crown Court. The next matter of consideration, roles of the judge and the roles of the jury. Now, if we consider the judge for the first part, the judge is the one who is the arbiter of the law. The judge interprets the law and the judge applies the law. Additionally, it is the judge who maintains order within the courtroom. He's the one who sits, he oversees, he presides over the proceedings. Now, it is for the judge also to instruct the jury as it relates to what the law that is to be applied in any particular case before them, and also he instructs the jury on what the legal standards are, for example, on whom the burden of proof lies. The judge is also the one who determines what evidence can be admitted and what evidence can be presented to the jury. So, for example, there is a matter of what's called the fruit of the poisonous tree. So, for example, if the police were to raid premises and they did not follow the correct procedure and then they find something within the property, but it was then confiscated, and it may well fall under what is termed the fruit of the poisonous tree if in the end the search was deemed illegal but they found something that was very important. How do you manage to get that before a jury? Well, it is for the judge to make that decision. And lastly, the judge is the one who imposes sentence in the event that the jury finds the defendant guilty. For their part, The jury is the arbiter of fact, which means the jury is the fact finder. They determine what, as a matter of fact, is what is before the court. So if they decide that there was a red car traveling on a particular street and they find that as a matter of fact, that is down to the jury. Additionally, they're there to hear the evidence as presented by the prosecution and the evidence as presented by the defense, and by and large, they are the ones who determine guilt or innocence of the offender, and in finding that guilt or innocence, they usually deliberate in private in order to get to a verdict. The entirety of this, therefore, is that there needs to be an impartial, unbiased approach to their decision making, and that is very important when it comes to a jury trial, because the jury room is more or less sacred, it's sacrosanct, and it's left to them to make the decisions insofar as they see fit, but insofar as they listen to any directions given by the judge. Now, as we end on this final segment, then we look at the jury direction, and what that means simply is, what does the judge say to the jury? What are the things, and how does the judge guide the jury? Well, as we indicated, the judge is the arbiter of the law, so the judge will guide the jury on what evidence is admissible. He will also summarize the facts for the jury, and the judge will guide the jury on what is the standard of proof, which in a criminal trial is beyond reasonable doubt. The judge will also guide the jury on what is the burden of proof and who has the burden of proof. Now, in a criminal trial, the burden of proof is at all times on the prosecution. And unless you have a situation where the burden of proof, particularly for certain evidential matters, may be reversed, it remains on the prosecution. Lastly, it is up to the judge to direct the jury and explain to them the difference between law and facts. Now, if the judge has directed the jury properly, then there is no appeal in respect of that. And just for the record, you can only appeal on a matter of law. You cannot appeal on a matter of fact. If, however, the judge has misdirected the jury, then there may be an appeal on the law. And this is why when you get exam questions, which will ask you, or rather set out a scenario where there has been a misdirection, and it is for you to now decide how the judge has misdirected, how the law has been misapplied, and it will usually be for you to then give an answer explaining what ought to have been done by the judge in all of the circumstances. Now that completes and concludes our introduction, and we're going to go forward in the next lecture looking at criminal liability.